5 seconds to go. Start. For instance, if facts within the special knowledge of the accused are not satisfactorily explained, that could be a factor against the accused. Stop. Though such factor by itself is not conclusive of guilt, it becomes relevant while considering the totality of the circumstances. Stop. A proper explanation of one's conduct or a version different from the prosecution version, without being obliged to face cross-examination, could provide the necessary hint or clue for the court to have a different perspective and solve the problem before it. Stop. The exercise under section 313, instead of being ritualistic, ought to be realistic in the sense that it should be the means for securing the ends of justice, instead of an aimless effort, the means towards the end should be purposeful. Stop. Indeed, it is optional for the accused to explain the circumstances put to him under section 313, but the safeguard provided by it and the valuable right that it envisions, if availed of or exercised, could prove decisive and have an effect on the final outcome, which would in effect promote utility of the exercise rather than its futility. Stop. Para. Once a written statement is filed by the accused under subsection 5 of section 313, CRPC, and the court marks it as an exhibit, such statement must be treated as part of the accused's statement under subsection 1, read with subsection 4 thereof. Stop. Para. In view of the later subsection, the written statement has to be considered in the light of the evidence led by the prosecution to appreciate the truthfulness or otherwise of such case, and the contents of such statement weighed with the probabilities of the case, either in favor of the accused or against him. Stop. Para. This is a case where it does not appear from the records that the written statement Exhibit 96 engaged the attention of both the trial court as well as the High Court. Stop. Applying the principles noted above and for the reasons discussed below, there can be no quarrel that non-consideration of Exhibit 96, to a limited extent, in relation to recording of conviction and consequently imposition of sentence, has rendered it vulnerable to interference. Stop. Para. Exhibit 96 refers to inculpatory admissions as well as seeks to bring out exculpatory circumstances. Stop. The statement has to be read in its entirety. Stop. The inculpatory admissions emerging from this statement against the appellant are his presence at the spot and sustaining of injuries by the victim and the other prosecution witnesses while the appellant, as claimed, was attempting to save himself from getting injured. Stop. The exculpatory circumstances sought to be established are the appellant's description of the act complained of as involuntary, which was compelled by inevitable circumstances and not guided by choice, and, sustaining of injury by him in the same transaction. Stop. Para. In view of the inculpatory admissions appearing from Exhibit 96, the trial court, and the High Court, while concurring with the trial court, need not have labored much to convict the appellant as the person instrumental for the homicidal death of the victim by discussing the evidence led in course of the trial in details. Stop.